immigration lawyer, Ivon Simpson. Thank you for joining us, Ivon. Well, we learned today, Ivon, that even if the ECHR says, well, this plane can't take off, you can't fly migrants to Rwanda, to East Africa, the Prime Minister will overrule that ruling. So that's good news, isn't it? The migrant plan can start to work.
Well, the starting point, any such statement in itself is unlawful, because you can't overrule something unless you know what that something is. We don't know what the grounds for those challenges are. And if we don't know what the grounds are, how can we ban it? They may be very good grounds why somebody wants to challenge not being removed to Rwanda. And Strasbourg will look at that, look at the evidence, and decide whether Rule 39 injunctions is the right course of action. So it's a bit worrying for the Prime Minister to say he's going to ban something, overrule it, and he doesn't know what that something is until somebody actually makes an application.
But then, you know, the argument here that ex-immigration minister Robert Jenrick is making, a man you'd think who would know a thing or two about the law in this country regarding immigration, deportation and the like, has basically said if you allow individuals to then appeal the decision by the Home Office, a.k.a. His Majesty's government, that you don't have any legal basis to stay here, and everyone's allowed to appeal against it constantly, or appeal against going to Rwanda for their processing, then no one's going to be on a plane and nothing's happening.
That's not strictly correct. What they're challenging is being sent to a country which they don't feel they're going to be safe in. And the Supreme Court agreed with that. The assurance was given by the Rwanda government and the UK government that Rwanda is a safe country and would not further remove asylum seekers to other countries, a principle called refoulement. They didn't accept that. What the government's done is said, we're going to put it into law. We're going to tell everybody that Rwanda's safe, and we're going to enact an act of parliament to say so. It's almost like saying black is white and white is black. They should read the human rights reports on Rwanda, what actually goes on in that country, the arbitrary detention of political opponents, the extrajudicial killings by Paul Kagame. I mean, people just seem to ignore all of those facts, independent reports, which don't describe Rwanda as safe.
Well, so surely if you're someone who is going to have your application for asylum in the UK processed in Rwanda, you're unlikely to be standing against Paul Kagame in the next election.
I'm not sure I understand your question.
Well, you're saying that, you know, you're saying people need to look at Rwanda and look at extrajudicial killings of Paul Kagame and what happens to his political opponents. My argument is, having lived in East Africa and knowing the region pretty well, that may be the case, but I don't regard Rwanda as unsafe. And I can't see why someone who's entered the country illegally, who's being processed in Rwanda, would be at any risk of being regarded as a political opponent of Paul Kagame.
Well, that's the freedom of expression that we enjoy, protected by the Human Rights Act. And I don't know whether you've read the Human Rights Watch report on Rwanda or the Amnesty International report on Rwanda. I have. And I can tell you there's overwhelming evidence which says that is not a safe country. I would defy you to go into the central square. Are you telling me, Ivon, that when I go to watch Arsenal play, I hate to watch Arsenal play, but when I do, and on the front of the players' shirts is go on holiday to Rwanda, that we really shouldn't take the advice of those people at the Emirates? I mean, you know, is this country really unsafe? But I'll tell you one, you and I, we've had some ding-dongs in the past, but here's an area I think we might agree on. It's this, the absurdity of the Supreme Court. I don't agree with the Supreme Court, but it ruled that Rwanda was not a safe place, that human rights were not enshrined there properly. That was its decision. So the Prime Minister of the country that is judged by the Supreme Court says, right, I'll pass an act saying that Rwanda is safe. We'll get 650 MPs, most of whom couldn't point to Rwanda on the map, to say Rwanda is safe. There's something absolutely sort of bizarre about this, isn't there? It is, and I mean, there's a conflict between Parliament and you know, Jacob Rees-Mogg. We've had lots of ding-dong with him. He goes on and on about the sovereignty of Parliament. We can't have mob rule. There's universal laws that we've got to comply with. But listen, Kevin, go into Rwanda, get a placard and write on it, Paul Kagame out, and let's see what happens to you. Because you say it's safe.
It's a deal. No, I won't do that.
Yes, and you know why you won't do that?
In East Africa, don't worry me.
That.
But, you know, what I want to ask
it's not
you...
a safe country.
What I want to ask you, Ivon, is this. Let's get back to the detail of what's being debated in Parliament today, what's likely to get through the Commons, if anything does, and what's likely to come out the other side of the Lords, and whether that's likely to actually see this policy be put in action.
Yeah, I don't think the amendments will probably get through. And if they did get through, they're going to be unlawful, because what you can have, even if Parliament says that it's safe, look, Parliament's supreme, and the judges have to then apply the will of Parliament. However, what you can't legislate for is individual cases. So each individual have exceptional, compassionate, particular set of facts, and there has to be an element of discretion for the courts to look at those facts. And the human rights is about exactly that.
But you do agree, though, Ivon, you do agree that Rishi Sunak has made it clear in this Rwanda safety bill that only in very exceptional circumstances will individuals be able to appeal. So the idea is that no more of this kind of long procession of people appealing. They'll be cut out of the equation.
I agree with that. I think that's absolutely right. There should only be a limited number of appeals based on hard facts and evidence. In actual fact, the benchmark is really high for the evidential burden on the applicants, because they've got, for example, if you say I've got suffering from depression, and if I go to Rwanda, it's going to get worse because I fear for my life in Rwanda and my depression is going to deteriorate, you need medical evidence to prove that. You can't just raise arguments without hard expert evidence to back it up. So the government's been quite clever. They've raised the evidential burden very, very high. There'll be very few cases where Rishi Sunak has to do that.
Oh,
that's good. Well, that's good anyway. Thanks, Ivon.
Thank you
Always a pleasure.
much.